Okay, let's unpack this. We're diving deep into, well, frankly, one of the trickiest areas in criminal law, intoxication. Specifically, how the Model Penal Code, Section 2.08, handles it.
It really is tricky because you've got this fundamental tension, right? The law demands we prove a specific mental state, the mens rea. But what happens if someone's so intoxicated they just couldn't form that state, especially if they chose to get intoxicated?
Exactly that tension. So our mission today is to really break down the MPC's approach. We need to clearly separate voluntary intoxication, which usually isn't a defense, from involuntary or pathological intoxication, which sometimes can be a complete excuse. Understanding this is just critical for you, the listener, in almost any crim law analysis.
Absolutely. And to do that, we need a clear plan. First, we'll hit the main rule. Intoxication isn't a defense unless it negatives an element. Then, crucially, we'll look at the big exception, the special rule for recklessness crimes.
Okay.
And finally, we'll get into those rarer situations, the involuntary and pathological cases, where intoxication can actually function like an insanity defense.
Perfect. Let's start right there with that baseline rule. MPC Section 2.08 all 1. If someone's voluntarily drunk or high, the law generally says tough luck. But you said sometimes it can matter. When?
Right. The rule itself, 2.081, says intoxication of the actor is not a defense unless it negatives an element of the offense. The key thing to grasp here is that voluntary intoxication itself, it's never an affirmative excuse. You don't just say, I was drunk, so I'm innocent.
Okay, so it's not a shield.
No. Instead, you use the evidence of how intoxicated you were to argue that the prosecution hasn't proved its case. Specifically, that they haven't proved you had the required mens rea. And this really only works for crimes that need a high level of intent, like purpose or knowledge, what we call specific intent crimes.
Okay. So it's about attacking the prosecution's proof, not offering an excuse. That feels like a really crucial distinction. Let's use a concrete example. Let's analyze a situation. Say someone's charged with theft, and under the law, theft requires the purpose to permanently deprive the owner. The facts show this person was extremely drunk, took someone else's car, drove it literally just around the block, and then abandoned it. They testify later, look, I meant to bring it back, I forgot where I left it. First, what are the legally dispositive facts?
The key facts are: 1, high level of intoxication; 2, took the car without permission; 3, abandoned it quickly and nearby; and 4, credible testimony suggesting they lacked the purpose, the specific intent, to keep the car permanently because of that intoxication.
Got it. And what was the core legal issue the court faced?
The issue was, did the defendant's self-induced intoxication actually prevent them from forming the specific mental element required for theft? That is, the purpose to permanently deprive the owner.
Okay. So what rule of law did the court apply? Please state the full black letter rule, MPC 2.081, and break it down. What are the testable elements here?
All right. The rule is 2.081. Intoxication is not a defense unless it negatives an element. For a case like this, testing the mens rea element, we need to see if two things are true. First, does the offense require a mental state higher than recklessness, like purpose or knowledge?
Right.
And second, did the intoxication actually, factually, prevent the defendant from forming that specific mental state?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element? Offense requires purpose knowledge.
Okay, mini IRE time for element 1. The crime is theft. The rule, the definition of theft, requires purpose to permanently deprive. Since purpose is definitely a higher mental state than mere recklessness, the first element is met. That means the court can consider the evidence of intoxication. The door is open.
Understood. Now, what about the second element, intoxication factually negated intent? This feels like the core of it.
It is. This is all about the facts. Mini IRAC 2. The court looks at the defendant's claim, I didn't intend to keep it. Then it looks at the circumstances. Drove it just a block. Abandoned it right away. Combined with evidence of extreme intoxication, the court could reasonably conclude, yeah, this person likely did lack the conscious objective, the purpose, to keep the car forever. So the intoxication factually negated that specific intent element.
And after analyzing all the elements, finding the crime needed purpose, and that the intoxication likely negated that purpose, what was the court's final conclusion?
The conclusion would be an acquittal on the theft charge. Not because being drunk is an excuse, remember, but because the prosecution couldn't prove every element of the crime specifically. They couldn't prove the defendant acted with the purpose to permanently deprive. The intoxication evidence defeated that element.
That makes complete sense for specific intent crimes like theft. But, as you mentioned, this whole analysis kind of flips on its head when we talk about crimes requiring only recklessness. This is the MPC's big policy move, right? What's the rule there in 2.08 and why is it so different?
Yeah, this is the famous or infamous recklessness trap in Section 2.082. The rule is quite specific. When recklessness establishes an element of the offense, if the actor, due to self-induced intoxication, is unaware of a risk of which he would have been aware had he been sober, his unawareness is immaterial.
Oh, immaterial. So the law just pretends you were sober. It says, we don't care if you were too drunk to realize the risk. If sober you would have realized it, that's enough.
That's exactly it. The law essentially imputes the awareness of the sober person onto the intoxicated person. It holds you to the standard of your sober self.
Why? That seems incredibly strict. Isn't that basically punishing the act of getting drunk itself?
That's the policy debate. But the MPC drafters felt it was necessary. Think about it. Recklessness is the mental state for so many common, dangerous crimes: manslaughter, assault, reckless endangerment. If getting drunk could just erase the awareness of risk, part of recklessness.
Then anyone could just drink their way out of liability for those crimes.
Precisely, the system could collapse for those offenses. So the MPC made a hard choice. If you voluntarily become intoxicated, knowing or reasonably expecting it impairs you, you bear the risk. You're held responsible for risks a sober person would have seen, even if you didn't see them in your intoxicated state.
Okay, that policy rationale helps explain the harshness. Let's test this with a scenario. Let's analyze the situation. Defendant gets very drunk, self-induced, in a crowded bar, decides it's a great idea to play darts blindfolded. Truly believes, in their drunken state, that they're amazing and no one's in danger, but inevitably hits someone. Charge is reckless endangerment. First, what are the legally dispositive facts?
Okay, key facts. 1, the intoxication was self-induced. 2, the defendant was subjectively unaware of the obvious danger throwing sharp objects blindfolded in a crowd. 3, a sober person absolutely would have been aware of that substantial and unjustifiable risk.
Got it. And what was the core legal issue?
The issue is, can the defendant use their intoxication-caused unawareness of the risk to say they didn't meet the mens rea for recklessness, which normally requires subjective awareness?
Right. What rule did the court apply? State the full rule, 2.008, and break down its elements for imputing awareness.
The rule is 2.082, which we just discussed. It imputes awareness, essentially treating the defendant as if they were aware if 2 elements are met. 1, the intoxication was self-induced, and 2, the actor was unaware of a risk they would have been aware of if they were sober.
Thank you. Now for the court's elemental analysis. Let's start with the first element. Was the intoxication self-induced? How does the MPC define that in Section 2.088B?
Okay, mini IRAC for element 1. The rule in 2.08b defines self-induced as intoxication caused by substances the actor knowingly puts into their body, knowing or having reason to know they tend to intoxicate. Here, the defendant chose to drink alcohol at a bar. No coercion, no medical reason mentioned. So yes, element 1 is met. It's self-induced.
Understood. Now, what about the second element, unawareness due to intoxication? The defendant honestly didn't see the risk. Why doesn't that matter?
Right, mini IRE 2.2. The defendant claims subjective unawareness. But the rule asks, would a sober person have been aware? Clearly, yes. Throwing darts blindfolded in a crowd is obviously dangerous. Because the defendant's unawareness was caused by the self-induced intoxication, Section 2.082 kicks in and says that subjective unawareness is immaterial. We substitute the sober person's awareness. Element 2 is met.
So the law effectively says your subjective reality while drunk doesn't count here because you chose to get drunk. And after analyzing both elements, what was the court's final conclusion?
The conclusion is that the defendant is deemed to have acted recklessly. Their attempt to use intoxication to negate the recklessness element fails because of 2.08-2. They would likely be found guilty of reckless endangerment.
Okay, that contrast is stark. Voluntary intoxication might negate purpose or knowledge, but it gets trapped by the special rule for recklessness. Now, let's shift gears to the exceptions, the times when intoxication can be a full defense. When does it become involuntary or pathological and get treated like insanity?
Right. This takes us to Section 2.084. This says that intoxication which is not self-induced or which is pathological is an affirmative defense if, because of it, the actor lacks substantial capacity either to appreciate the criminality, wrongfulness of their conduct, or to conform their conduct to the law.
So it mirrors the insanity standard, like MPC 4.01.
Exactly. It provides a defense that's coextensive with the insanity defense, but only for these specific types of intoxication.
Let's use a really visceral hypothetical here to pin down non-self-induced. Imagine someone goes to the dentist, gets a normal dose of nitrous oxide laughing gas, standard procedure. But while recovering, they have a totally unforeseen, bizarre allergic reaction, become psychotic, and trash the recovery room. What part of the MPC definition makes this involuntary intoxication?
That scenario fits neatly into an exception listed right in 2.2085b, which defines self-induced. It says intoxication is not self-induced if it's caused by substances taken under medical advice, since the dentist administered the nitrous oxide as part of treatment.
It doesn't matter how weird the reaction was.
Correct. Because it was pursuant to medical advice, it's legally not self-induced, it's involuntary, and that activates the potential affirmative defense under 2.084. Then the question for the jury would be whether, during that psychotic episode, the person met the insanity-like standard lacking substantial capacity.
Okay, clear distinction based on medical advice. Now for the other odd category. Pathological intoxication. What if someone has, say, one small glass of wine, but unknown to them, they have some incredibly rare condition that makes them react with extreme psychosis, a reaction totally out of proportion to the alcohol? What defines this defense under 2.085?
Yeah, pathological intoxication is fascinating. It's defined in 2.08c and needs two things. First, the intoxication has to be grossly excessive in degree given the amount consumed. One glass of wine doesn't normally cause psychosis.
Right.
Second, and this is critical, the person must not know they have the susceptibility. If you know you react bizarrely to even a little alcohol and you drink anyway, it's back to being treated like self-induced. But if both conditions are met, grossly excessive reaction, and you didn't know you were susceptible, then it's considered pathological.
If it's pathological.
And then, just like involuntary intoxication, it qualifies for the affirmative defense under 2.084, judged by that same insanity-like standard of lacking substantial capacity. Okay, we've covered a lot of ground. The general rule, the recklessness trap, involuntary, pathological. We've broken down MPC 2.08 piece by piece to really cement this for someone facing, say, an exam question on intoxication. What's the step-by-step diagnostic checklist? How should you structure the analysis?
Great question. Having a framework is key to not getting lost. Here's a 5-step approach you can use.
Define the intoxication. Was it self-induced? Check the exceptions immediately, medical advice. Coercion. Pathological reaction you didn't know about. If yes to any of those, it's not self-induced, and you jump straight to step 5. If no exceptions apply, it is self-induced, so proceed to step 2.
Okay, step 1. Self-induced or not. Got it.
Step 2. Identify the offense's mens rea. What mental state does a specific crime require? Purpose, knowledge, recklessness, negligence. You need to know this precisely.
Right. Match the intoxication type to the required intent. Step 3. Check for recklessness, the trap. If the crime only requires recklessness and the intoxication was self-induced from step 1, then STOP. Section 2.02 applies. Awareness is imputed. Intoxication is irrelevant as a defense here. Liability likely follows.
So recklessness plus self-induced, analysis over.
For negating the mens rea, yes. Step 4. Check for specific intent, negating an element. If the crime requires purpose or knowledge and it was self-induced intoxication, now you ask the factual question from 2.08. Was the intoxication so severe it factually prevented the defendant from forming that specific intent? If yes, the prosecution can't prove its case. Acquittal on that charge.
Okay, that's the narrow path for voluntary intoxication.
Exactly. And finally, step 5, affirmative defense check. This is where you land if step 1 determined the intoxication was not self-induced, involuntary, or pathological. Now you apply 2.08. Did that involuntary or pathological intoxication cause the defendant to lack substantial capacity to appreciate criminality or conform conduct, just like the insanity test? If yes, they have a complete affirmative defense.
That framework really pulls it all together. Define the type, check the mens rea, watch out for the recklessness trap, see if specific intent was negated, or check for the full affirmative defense if it wasn't self-induced.
That's the logic of 2.08 laid out. It tries to balance holding people responsible for voluntary choices with the basic principle that you need the required mental state for a crime.
So we've seen self-induced intoxication rarely works as a defense, mostly just potentially negating purpose or knowledge. And involuntary or pathological intoxication can be a full defense, mirroring insanity. Here's a final thought, something for you to chew on. The MPC explicitly says in 2.083 that intoxication itself doesn't count as a mental disease for the insanity defense. Fair enough.
Mm.
But what about the long-term effects? Say someone drinks heavily for years, self-induced choices, yes, but develops actual permanent brain damage like alcoholic dementia. Does that permanent condition caused by past voluntary intoxication but now existing independently potentially qualify as a mental disease or defect for a standard insanity defense under 4.01, separate from the immediate intoxication rules? Or does 2.08 somehow bar even that?
That's a really tough question, and it pushes the boundaries. Where does the effect of the substance end and a separate, settled condition begin? Courts grapple with that line all the time. Something to think about.